David.
Yeah, thank you very much, and thank you to our witnesses. In fact, you've jumped ahead, really, towards the question I want to ask you, if I may, about the difference in British legislation between an employee and a worker, and does that make a difference? Similarly, the European Convention on Human Rights, and indeed other international conventions and things that we've signed up to, do they make that same distinction, and does it have any real impact, therefore, on the protections that Dr. Collins, Ms. Banton and Professor Fredman that you've outlined to us this afternoon?
Well, Elaine's best place to...
No? Sandy going first on this one.
Okay, well, so as I said, in the 70s when the employment statutes were set up, there seemed to be a clear divide between people who are under the employment contract and people who are in business on their own account. And the employer should not be thought to have responsibility for those workers who are in business on their own account, like your plumber who you get into your home to do the work. But as we've been saying, as the workforce has changed, more and more people are moving into a kind of a grey area where they are not in business on their own account, although they're called independent contractors. And so a new category was brought into both the employment legislation and the trade union, the collective legislation, which said that there was an intermediate class of worker who was providing work under a contract for personal services, but the other party was neither a client nor a customer. So, if you're a plumber, or you might be providing work to a client, but if you're a plumber employed in some large organization and you're so-called self-employed, but really the business is telling you what to do, where to go, then you're providing personal services, but it's not your client or your customer in that sense. So this intermediate category, which is quite, it was at the time quite foresighted to think we could have another category of workers. But the importance of it is that there's now a kind of hierarchy of rights under the employment statutes, that the workers who are still can be considered to be under a contract of employment, which is so-called under the control of the employer and in regular formal work. Those workers have the whole panoply of rights, which include unfair dismissal, rights not to be made redundant, although there's a 2-year eligibility criterion now, so it's not as strong as it could be, and some of the parental leave, shared parental leave, maternity and paternity leave. Whereas this, what we're now calling Limb B worker, which are the workers who provide personal services but not for a client or customer, they have rights to the national minimum wage, rights to maximum working hours, which would include paid holidays, and then rights, for example, since quite recent amendments to itemized particulars of their employment arrangement, and some of rights, whistleblowers' rights. The difficulty is that it's easier described than actually classified. So what we've had is a lot of skirmishes on the borderlines, particularly around the concept of what is it to provide a personal service. If I am allowed to get someone else to do the work for me, does that mean I'm actually kind of an employer myself? Am I an independent contractor? But quite often it's quite easy to put a clause into the contract to say if you can't do it, you can get someone else to do it. But in practice, you never do, or you can't. So there's a lot of grey areas which have caused quite a lot of litigation. And the courts are now have a concept of what's called a sham contract, which makes it look as though you're not a Limb B worker, but you're actually in business on your own account. But actually, in practice, you are, and we can perhaps talk more about that. But I could talk about the difference in the European Convention very quickly, because under the European Convention, as Philip has said earlier, everyone has the right. So you would think that there wouldn't really be these complex distinctions, which don't necessarily reflect the substance of who should have rights. it can become very technical and divorced from the question of, actually, I'm a rights bearer, regardless of how my employer, cleverly or not, writes my contract. Yeah. And under the European Convention, it says everyone has the right to freedom of association, everyone has the right to freedom of speech. But some of the cases under the European Convention, and I imagine Philip and Elaine could both say more about this, have said that what we should do is apply a concept of worker which comes from the ILO, the International Labour Organization, which basically says there's always a presumption that you're a worker. That's the first thing. So the employer would have to justify saying you're not. Secondly, we should always look at the facts and not at the written document. And thirdly, there should be a whole lot of indices where we can decide if this person is a worker or isn't. Mostly the court has said, say, the clergy, district judges, even foster carers who are governed by law rather than contract. They've been said to be workers within the convention, whereas they possibly would not be LIMB workers potentially under the statute. So it's a wider concept, but it's still a little bit fluid, and it's not necessarily gone all the way to saying everyone has this right. There's a case right now before the Supreme Court which is perhaps going to say more about that.
Thank you very much indeed.
Name of that case?
The Deliveroo case.
Yes, of course.
I won't say anything about the judgment, but it's about Deliveroo workers, whether they can be said to be LIMB or workers for the purpose of freedom of association under Article 11 because they wanted to form a trade union.
We should be watching out for the judgment.
The hearing was in the end of April, so the judgment's going to come up very soon. It's the international. It's the Independent Workers Union.
We're not discussing it.
Independent Workers Union of Great Britain. It's not called Deliveroo. It's the Independent Workers of Great Britain, because they were the ones who wanted to form the trade union.
We should watch out for the judgment in that case. We have very strict sub judice rules in Parliament that we can't discuss these things.
That's right.
But I don't think there's any harm in me asking you when the judgment's coming out, and our fantastic team will watch out for it.
Yeah, do watch out for it. It's going to come out pretty soon, I imagine.
Oliver, I think you wanted to comment.
Well, just a quick question of clarification, because I'm a bit confused. But does it help? I'm thinking back to my days 30 years ago as a minister in the old Department of Social Security. If one looks at the distinction with national insurance contributions, between was it Class 1 and Class 2, as to whether you were employed or self-employed, and it wasn't a matter for the employer, it was a question of fact as to whether you genuinely were working as a worker or an employee for that person, and your relationship with them, or whether you were self-employed. Does that make it simpler for me to understand if I put it in those terms?
Yes, possibly, but one of the difficulties, I think, is that the same term was used in different contexts. Tax, social security, vicarious liability. For example, if an employer, if a worker has an accident or is negligent, then the same concept is also applied. So in all these different contexts, some of the cases are read across, but sometimes it doesn't work so well to read across a vicarious liability case to a social security case to a tax case. So actually the employment cases are kind of been developing along their own lines. And I think, I'm not an expert in social security, but I don't think
I'm 30 years out of date.
I don't think there's a LIMB equivalent, which there is under the employment statutes. And so this has grown up. But the bottom line is that courts have always said, but even more now, are saying you should look at the factual situation. And it's very easy to document things in one way in order to avoid particularly national insurance contributions as well, or to avoid vicarious liability as well. But the real reality of what is it that the worker actually does the worker actually get a substitute if they can't work? Do they really provide the personal service? Is how the courts are looking at it, and I think that's a positive development.
I think there's been a real shift, just to add to what Sandy's saying. In the last even few years since I was writing my PhD, you saw a real shift in the courts being really keen to not just read the contract and say, oh, well, your employer has written this contract and that looks like self-employment, so we'll put you in that box. They've been really keen to engage with the facts, to look at why we have this piece of legislation, what's the purpose of that, who needs protection, and then kind of go from there, this idea of a purposive approach.
In other words, exactly as we always felt with national insurance contributions, it wasn't for the employer to decide whether the individual was employed or self-employed. It was a question of facts as to how his or her employment was or wasn't working.
Yeah. Exactly. Yeah.
Thanks.
Thank you very much indeed for your answers.